So welcome everyone to this webinar on the legal aspects of doing business in India. I will be moderating today. My name is Anton Garmosa. I'm a partner at Cardinals, the head of international arbitration. Our speaker today is also a member of our team, a counsel at Cardinals, Reena Choudhury. And Reena is a very experienced Indian lawyer. Her specialty is not only in dispute resolutions, but also in overseeing transactions and providing corporate legal advisory to various clients, including blockchain, fintech, and tech startups and multinational companies. But of course, Reena is also an advocate on record with the Supreme Court of India, so she is also an experienced litigator, having experience in contractual disputes, shareholders disputes, and this is something we may touch upon on today, but the main topic, of course, for today will be doing business in general, starting up a company in India, trading with India companies, and things like that. But we'll may get to disputes at some point as well. So the way this will be structured is that first I'll open up a floor for Reena for a quick presentations, maybe about 15 minutes, where Reena will go over some basic aspects of doing business with India. And after that, we'll open up for your questions. So if you have questions in the meantime, there are two ways to pose them. You can pop them in the chat box, and my colleague Artem will be collecting those and will address them to Reena. Or also, after Reena is finished with her presentation, you may just raise a hand and ask your question. With that, without further ado, I give the floor to Reena for her presentation.
Thank you so much, Anton, for that wonderful introduction. And good evening, everyone. It is really exciting to be able to speak on today's topic, which is to talk about the legal framework and the step-by-step guideline on how to set up your business entities in India. So given the Indian government's push to welcome foreign investments in the past decade, so India has become one of the major preferred destination for several multinational companies who are starting to set up their branch offices or set up their manufacturing units in India. So over the past decade, actually, the foreign direct investment in India has risen manifold. And this is actually a great time if somebody is looking to diversify their businesses. So setting up business in India, given the government's push to for ease of doing business in India, this is actually a very good time, I would say. So yeah, I think it's a very exciting topic to dive into the legal framework and the step-by-step guideline on how to open your and set up your business structure. So as Anton suggested, we would first give you a brief overview by means of a presentation. It's a very short presentation, but it would give you a general idea on what all it takes to start your business here. So I'll just one second share that presentation, and if you have any further questions on that, you are most welcome to discuss those at the end of the presentation. Anton, is the presentation visible now?
Yes, I can see that.
Okay, perfect. So Anton also suggested that most of the clients here are from Russia. So I don't know if anybody else has joined, but just to give you a brief overview of what has been the trade relations between India and Russia in the past couple of years, that has actually also increased by a lot since post-pandemic era. And actually in 2024, which is the last year, the trade between India and Russia reached a record $66 billion. And we have major imports from Russia, around $60 billion plus, and India's exports amounted to about $4 billion. So there is a major push from the Indian government also to increase the exports to Russia to sort of reduce the trade deficit between the countries. Now, these are the major items of import from Russia that India is currently doing. So Of course, the first major item is the oil and petroleum products, the bitumen substances, and the fertilizers. We are also heavily importing precious metals and stones and heavy machinery and equipments and a lot of vegetable oils and wood, pulp, and paper products from Russia. So, uh, we can discuss about that later. But I have actually helped set up about a company here last year which was dealing in the trading of heavy machinery. So that was a Russian entity, and they expanded their business here by setting up an independent legal entity here, and they are currently doing business in India and also overseas through their legal entity. So there are a lot of Russian entities now coming up and setting up businesses, especially in the heavy machinery sector and also the precious metals and stones. And a lot of them are also setting up manufacturing units for fertilizers and uh, other substances. And when we talk about what the Indian clients are interested in the Russian side of the business, so these are the key Indian exports which we are exporting to Russia. So these are obviously the agricultural products. We are heavily exporting the rice, coffee, grapes, tobacco. Then there are, of course, smartphones. Now there are a lot of companies who are setting up their entities in India to assemble the smartphones, and then we export those out. Then, of course, the aeroplane components and a lot of clothing and knitwear items, which includes a lot of cotton clothing items and leather goods also, and iron and steel also we are heavily exporting. So these are some of the major key items of export which India is currently doing. And when we talk about what the two countries are looking to do in future, so they recently set a target of achieving a bilateral trade of about $100 billion by 2030, which is just 5 years from now. So as you can see, both the governments are really interested in increasing the amount of trade that is happening currently between the countries. And as per the official websites, these are the major areas of collaborations that the countries are looking into increase, such as the artificial intelligence sector, the robotics, urban development, and metals like lithium, cobalt, and nickel. So these are the areas of interest that the governments would be heavily pushing in the coming 5 years. Now, when we talk about setting up business entities in India by a foreign national, when I say foreign national, the foreign national could be a foreign individual or a foreign legal entity, which could be a partnership firm, a limited liability partnership, or a corporate entity. So the types of business structures that they can set up in India are, you know, about nine. There are other types of legal structures, the corporate structures in India, but they are not allowed to be set up by a foreign national. So a foreign entity can only look at to set up a private limited company or a public limited company, an associate company, or a subsidiary of it. It could be a wholly owned subsidiary or just a simple subsidiary company, or they can enter into a joint venture agreement with an Indian partner here, or they can set up a limited liability partnership, which is the most favorable form of partnership here, the LLP. And of course, then there is a branch office that they can set up instead of setting up a whole company structure or a liaison office. So these are the types of business entities that they can set up here. And we will also briefly look at each one of them on what are the requirements on setting up on each type of entity and which one is the most preferred in terms of raising of capital and raising of finances from the banks, what the banks prefer here, which type of structure that they favor in, giving out financial loans if down the future the company is interested in raising further capital from the banks also. So let's just briefly talk about the private limited company. This now a private limited company is the most, I would say, the preferred form of company which is being set up here because you only require a minimum of two shareholders, so two people or two entities can become a shareholder in a private limited company and set it up. The amount of regulations that a private limited company is put under is also very less. The compliances are also very less when it comes to a private limited company as opposed to a public limited company. So two shareholders can come and set up a private limited company. Now these shareholders can both be individuals or one individual or one corporate entity, or both the shareholders can be corporate entity. And the only requirement is that there should be minimum of two directors, but one of the not all the directors also can be foreign nationals, but at least one of the director has to be a resident in India. Now what that means is that the director needs to be staying in India for at least a period of 182 days in the previous calendar year. That means that would make him a resident in India. So at least one director has to be an Indian resident. He can be a citizen of another country, but he has to be residing in India. But otherwise, all the directors can be foreign nationals, all the shareholders can be foreign nationals. There is no prohibition in that. And in a private limited company, of course, the right to transfer the shares are limited as per the articles of association. So the company can decide on its own articles of association what all right it needs to give to the shareholders. And of course, there is a prohibition on invitation to the public to subscribe for any securities of the company. So the public cannot invest in the company because it's a private limited company. Now, a person in a private limited company can also be a shareholder, employee, director at the same time. So what that means that the same shareholder, who's the same individual, if he's a shareholder, it can also be a director, can also be a CEO of the company. So you do not need different people to fill up those different positions for you. So if there are two people or three people, they can be the shareholders, they can be the directors, and they can come together and set up a company here. And there is no minimum capital requirement for setting up a company, but usually what I've seen and the usual practice is also that the company is registered with an authorized share capital of about 1 lakh Indian rupee, which is roughly about 1100 USD. Now this authorized share capital can also be changed further down the line through amendments in the articles of association, through passing of board resolution, but this is the usual which the company starts with. So these are the basic aspects of private limited company in India. So the main thing is that you need at least two people and two directors, and you can have a company of your own. And at least one of the directors has obviously to be a resident in India. Now, when we talk about the public limited company, so again, this has a limited liability, but there has to be a minimum of 7 shareholders, and there is no restriction on the maximum number of shareholders. The public can also invest in it and become a shareholder, but it always has to have a minimum of 7 shareholders. And when we talk about directors, there is a requirement of minimum 3 directors and maximum 15 directors in this company. And again, all the shareholders, all the directors can be foreign nationals, but at least one of the director has to be a resident of India. He can be a foreign citizen, but he has to be residing in India, which means he needs to be staying for at least a period of 182 days in the previous calendar year. Now, a public limited company can get listed on the stock exchange, and once the stock it's listed on the stock exchange, then its shares become can be traded openly on the stock exchange, and the public can invest in that. And of course, there are more legal restrictions on this type of establishment as compared to a private limited company, because the market regulator, the securities market regulator is also watching the company closely to ensure that there is no fraud happening on the public, and the money of the public is also secured and being put to the correct use. And when we talk about the capital requirement, there is no minimum capital requirement, but it is also usually set up with an authorized share capital of 1 lakh. It can be 1 lakh, it can be 10 lakh rupees, depending on what the intention objective of the company is, what kind of business it intends to do here, and how much capital it needs for that business. But at least 1 lakh rupees, it is usually the starting authorized share capital of the company. Now, there is another form of corporate entity structure, which is the associate company. Now, again, associate company can either be a private company or a public company. So the characteristics of it would be governed in the same way as that of a private company or a public company. But an associate company is a company which is not a subsidiary of it, but still the parent company has a significant influence on it. Now, at least again, one of the director has to be a resident in India, and minimum 20% and maximum 50% of the total share capital of the company is held by another company, or having control of the business decisions of the entity directly or indirectly. Now, when we talk about control of the business decision, this control can include the right to appoint majority of the directors, or control of the management, or the policy decisions which are exercised by another entity, either directly or indirectly, including by virtue of their shareholding or management rights, or shareholders' agreements or voting agreements, or in any other manner. So, in a nutshell, if a company holds minimum of 20% in another company, if suppose a foreign entity is setting up an associate company, that means it has a minimum 20% shareholding in that company here, but not more than 50% shareholding, then that would be an associate company, because then it would have some control over the managerial decisions of the company. So that is an associate company. So that is also a form of company structure that can be looked into. Now, if the company holds more than 50% of a shareholding of another company, then it becomes a subsidiary company of the holding company. So that is also one form of the corporate entity structure which is permissible in India. So you can have more than 50% of the shares which are held by a foreign entity, or which is called the holding company. And again, the same thing applies, which applies to a public or a private limited entity, which is at least one director has to be residing in India. Again, it can be a private limited company or a public company, and at least more than 50% of the shares are held by another entity which is governing its decisions of the, which is taking all the decisions in regarding to the company. Now, this subsidiary company cannot have the right to own the shares of the holding company, except if it is stated so in the articles of association. So the holding company can hold the shares of the subsidiary company, but the subsidiary company cannot be holding shares in the holding company. Now, there's another one which is the wholly owned subsidiary company. And so, as the name suggests, wholly owned subsidiary means that the parent company has 100% shareholding in this company. So, the 100% of the shares are owned by the holding company. The entire management and the control rests with the directors who are appointed by the holding company. So, everything is in the hands of the holding company. Again, it can be a private company or a public limited company, and at least one director again has to be residing in India. Now, there's another form of structure which is the joint venture company. So this is basically a joint arrangement between two parties, two companies, two individuals, and they form a company for a particular purpose, and their rights are defined as per their joint agreement. Their assets are defined as per the joint agreement. So it is a very flexible concept. The parties can decide on what rights each party would have, what sort of business the joint venture would be doing. Now, this is a business alliance between two or more companies where the complementary resources of the partners are mutually shared and put to use. Now, this through a joint venture company, a foreign business entity can have access to the already established distribution and marketing channels of the Indian partners. They can have access to the available financial resources to the Indian partners and the contacts of the Indian partners here. So that would really help in the ease the process of setting up operations in India. So if you already have an Indian partner here, then this is also one of the really preferred ways of doing business in India. And the amount of the levels of regulations and the control by the regulatory authorities is also lesser as compared to setting up a public company or a private company, because this is for a particular purpose where the two parties come together and define the purpose as well as the rights in their agreement, and everything is governed by their joint arrangement. Now, this again is a very preferred corporate entity structure in India. which is the limited liability partnership. So as opposed to a private limited company, the regulations are even lesser. The registration cost is also lesser, and there are lesser compliance norms in setting up a limited liability partnership. Again, so as the name suggests, the liability of the partnership is very limited in this, and as opposed to a partnership firm where the liability of the partners is unlimited in India, the partners do not have unlimited liability. They have a separate legal existence from the uh, corporate entity, and no partner is liable on account of the actions of the other partners. It is an easier process to start an LLP. There are lesser legal requirements. The only requirement is that there has to be minimum of two designated partners, out of which again at least one has to be residing in India. Again, he does not have to necessarily have to be an Indian citizen, just an Indian resident. And if there are both the partners are corporate entities, then the nominees of those two corporate entities would be the designated partners in such an LLP. So two corporate entities can also set up an LLP through their nominees, and they do not have to then comply with all the legal requirements of setting up a private limited company. It is a lesser registration cost. The time taken to set up a LLP is also lesser compared to setting up of a private limited company. Now, there's another way of doing business in India, which is to just have a branch office in India, as opposed to setting up an entire corporate structure. So the foreign entity can just have a branch office. But for those to set up a branch office, there are certain requirements that the company needs to follow. So one of them is that they need to be having a profit making record for the immediately preceding 5 financial years, which is year financial year in the home country, and they need to have a minimum net worth of 100,000 US dollars. Yeah, this to set up a branch office, they need an RBI approval, which is the Reserve Bank of India, which is the central bank of India, which regulates all the other banks. And once the RBI approval is granted, then they can set up the branch office, and then they do not need to renew. They do not need to seek the for renewal of the approval. Now, the only restriction in branch office is that it can engage in export and import of goods, but it cannot trade locally, which means that it can import goods from the foreign country, then it can export those goods out to some other foreign country, but it cannot buy and sell those goods within India through its branch office. Now, a branch office can generate revenue in India, and profits can be then repatriated to the foreign company's account after paying all the applicable taxes. So, if the company's business is such that it needs only a branch office here, then these are the conditions that need to be met before having a branch office. Now, another form is to have a liaison office here. Now, to open a liaison office, also you need an RBI approval, but the RBI approval is usually only granted for 3 years. And after 3 years, you have to seek a renewal for the approval of continuing with the liaison office. Now, for a liaison office, you need to have a profit making record of for the immediately preceding 3 financial years in your home country, and a minimum net worth of 50,000 US dollars. Then another thing to be kept in mind for liaison office is that a liaison office cannot generate any revenue in India. It cannot earn any income in India. So all its operations, all the expenses are met entirely through remittance from the parent company. So it cannot have its own income source in India. So it is mainly suitable for companies that are only wishing to explore the Indian market or to coordinate with other Indian entities, because they cannot do business through a liaison office. They can, of course, do licensing only through the liaison office. It cannot earn or generate any revenue for them in India. So these are the uh, basic overview of all the different types of corporate structures that a business entity can look when they are looking to have their business here. Now, as I said, uh, a private limited company is the most preferred way of doing business in India, uh, because the main reason for that is the generation of capital through a private limited company is much easier, and the banks here also prefer dealing with a private limited company or a public limited company as opposed to a limited liability partnership, because when the banks are dealing with a private limited company, they know that since it is a more regulated space, the regulatory compliances are higher in that, so they are more comfortable dealing with the private limited company. They are more comfortable in giving finances or raising loans in favor of a private limited company. So this is the most suitable form of business for a private limited company. Now, just to quickly go through the steps which are involved in setting up a private limited company, the entire process can take up to 3 to 4 months. So, first, you have to apply for the digital signature certificates for all the proposed directors in the company. Then, you have to seek a digital identification number for the directors. Once that is done, you have to reserve the name of the company. So, all this process, the entire process which is listed here, everything is online except opening of the bank account. All the entire steps are online. So the digital signature certificates are done online. The application for DIN is online. Then you have to reserve the name of the company. So that's a very quick process. Then you have to choose a registered office, which of course you need to have a physical registered office in India. And you have to have a proof of address, which can either be uh, uh, if you are buying that registered office, then the title deeds of that place, or if you are renting out or leasing out that property, then the NOC from the landlord and the lease deed for that particular place, that would be the proof of address for that registered office. Then you have to prepare the memorandum of association, which define the objectives of the company, what sort of business the company would be doing, and the articles of association of the company, which would define the rights of the shareholders and the powers and the duties of the directors of the company. Once you have prepared that, then you have to submit all the relevant forms to the Ministry of Corporate Affairs. Again, this all the submission of the forms is through the Ministry of Corporate Affairs portal, which is all online. Once that is done, then the MCA, which is the Ministry of Corporate Affairs, they give you the certificate of incorporation that can take about a month, if all the documentation is in order. After receiving the certificate of incorporation, the company has to apply for the PAN number and the TAN number for its tax filing purposes, which is the permanent account number and the tax deduction and collection account number. Now, once they have the PAN and the TAN, then the company needs to open its bank account, which again, if all the documentation is in order, uh, then the bank account can take up to 2 weeks for opening. And then the company has to apply for the GST registration, which is the goods and services tax, depending on the nature of its business. If it comes under GST, then it has to apply for GST registration. If it's doing import and export, then it has to have import export code. And then finally, it has to obtain the certificate of commencement of business, which can again take about a week. Once the company has this certificate, then the company can start running its business here. So, uh, yeah, that was the pretty much a broad picture of how to do a business, how to set up a business entity in India, what all business structures can you look into, what are the options you have, and what is the basic timeline for all these business structures that you need to set up in India. So,
Thank
yeah.
you. Yeah, thank you very much, Rina, for this comprehensive overview of various corporate vehicles you can incorporate in India. I'm sure we'll have some questions from the audience, and we have received some beforehand. Well, but while people are gathering their thoughts, there are a couple of questions I wanted to ask myself. So one of those, you mentioned how a lot of the steps in incorporating of the company can be done online because everything is possible digitally. The
Mm.
question that we get asked sometimes from the clients who want to incorporate and start trading as soon as possible, can we do everything online, or do we have to actually come to the jurisdiction at some point to sign the documents, to apply for opening a bank account? What is the case of India? How far can you go with online, and when is physical presence required?
So that's a very good question, and I have faced that in my previous dealings with when I was helping the foreign nationals setting up a business in India. So as I said, the entire process of setting up a business happens online in India. So everything is through the MCA portal, except for opening of a bank account. Now, like I said, the business can have all the foreign nationals, the business can have foreign nationals, the shareholders, they can have foreign nationals as the directors also. Now, unless if they are foreign nationals as a director, the director, one of the directors has to be present in India for that particular duration for a period of 182 days. So at least one director is permanently residing in India. So for a period of 182 days in a year, that director has to be in India, whether it's a foreign national or an Indian national. Other than that, nobody is physically needed in India except for opening of a bank account. Now, when I say that the opening of a bank account, you need to be physically present, who needs to be physically present? The authorized signatory of the company has to be physically present. So, if the company decides to nominate some foreign national as the authorized signatory, then that authorized signatory has to arrive in India on a business visa physically. He has to give his specimen signature. He has to carry the authorizing board resolution in his favor, where the company is saying that the board of directors have resolved to appoint him as the authorized signatory. That person would be taking control of the operations of the bank account. He would be handling the bank account on behalf of the company. So the bank would need to verify his credentials, his signatures, everything physically. So for that, the authorized signatory has to be physically present in India. Other than that, none of the shareholders, none of the directors, except one who needs to be a resident in India, nobody has to be physically present in India. Now, the question, the difficulty, the practical difficulty which comes is that uh, for everything, as I said, all the documentation has to be proper. So that is the step where practical difficulties come in. So when I say all the documentation has to be proper, that means if a document is of another country, suppose an identity proof is of another country, because we have to submit all the required document when we are seeking digital identification number for a director who is a foreign national. So when we are applying for a DIN number of a director, we need to give certain identity proof documents for him. Now, whenever a document is coming from another country, that document has to be properly notarized and apostle if it falls under one of those jurisdiction where apostillation is required. So once that is properly done, only then the Indian authorities would have a look at those documents. So the in my experience, the biggest difficulty, even in their own jurisdiction, they say that, oh, the embassy is not apostling this document, the embassy is not notarizing this document, so how can we do that? So that's when the the process gets stretched out. So when I say it takes about 3 to 4 days usually, once the documentation is proper, then it would take very less time. But in their own jurisdiction, sometimes the clients do not know how to get the documents apostle, or sometimes the clients do not know how to engage with their own embassies. So that's where the process is time consuming. They don't have to physically come to India, but all the documentation has to be properly authenticated.
Right, right. And that's, of course, something that we can help them with
Hmm.
to overcome this potential difficulties. Well, thank you very much for clarifying this. So I'm just, before asking further questions, I'm looking at the audience, and as I said, I encourage you all, if you have any questions, to jump in at any point. You can just turn on your video or press the react button with a little heart symbol at the bottom, and then choose a raise your hand if you want to do it that way. So by all means, if you have any questions, don't hold them, and please feel free to share. While we're waiting for the questions, Rene, another question I had is that you mentioned this various possible corporate entities that you can incorporate. Could you maybe speak a bit from your experience? You've mentioned, for instance, that you have some cases of Russian clients incorporating in India and establishing companies without, of course, disclosing any confidential information. What would be an example of the entity that they may have chosen, or that you may have advised them to choose, and for what reasons, and have there been any difficulties at certain junctures in the process of setting up the entity that you could speak of?
Yes, certainly. So usually, if the client is very clear in what sort of business it wants to do, our first preference is, and if it does not require raising of capital or financing from the banks, if the client is very self-sufficient in that aspect, then we suggest them to go for a limited liability partnership, because that's a much easier uh, entity to set up. The registration cost is much lesser, the compliance norms are very few, and the entire process is much faster. But if the client is very sure that it wants to have a limited liability company, then of course we suggest them to go for a private limited company instead of a public limited company, because usually that's what meets their requirement. Now, the difficulty, as I said, is only one, the language barrier, of course. So we as lawyers have to be very clear in communicating with them, and also communicating with them in very simplified uh, words, because sometimes the clients, since they come from different jurisdictions, they are not aware of what all the legal requirements are. So we have to be really simplifying the entire procedure for them. And I've had clients who ask the same query, every second day. So I have to again keep repeating the same thing. But I understand, since it's a new jurisdiction and they also want to be sure. So that is not a problem. The practical difficulty is, managing the documentation part of it. So when I say that you have to get this particular document notarized in your home jurisdiction, then they come and ask me, oh, how do I get it notarized in my home jurisdiction? How do I approach the embassy here? So uh, sometimes we are able to help them out if we reach out to other lawyers in their home jurisdiction. So we have to navigate all of those areas also. But other than that, once the documentation is all done, we here try our best to manage. Sometimes even if the documentation is not proper, we have tried and figured out a way of handling those situations. If the client is really honest and is really looking to do a valid business here, so we have tried and helped them out, figure out a route. And yeah, so that's one of the major difficulties. So once the business is set up, then their main issue is with the bank accounts also. Now, when you have a business in India, you have to be sure of one thing, that the Indian banks would ask, they are under instructions from the Central Bank of India, which is the Reserve Bank of India. They are under instructions from RBI that for any money which is coming in India and which is going out of India, so if it's an Indian company doing business, doing export or import of items, or if it's a foreign entity, it does not really matter. Any entity which does export import of business, or the services are imported or exported, wherever money comes in, goes out of India, the bank has to know the valid reasons for the money coming in. The bank has to know the reasons for the money going out. So once that is clear, so how would the bank know? So you have to give all the documentation again to the bank. Suppose, to give you a very simple example, if you are exporting some goods out of India and the money is coming in, so you have to submit documentation to that effect. You have to submit the contract between the parties. You have to submit the invoices which is raised for the export of those particular goods. You have to, if the goods are going by ship, then the shipway bill has to be given, the bill of lading has to be given. If the goods are going by air, then those proofs have to be given. So all those documents are required to be given to the bank. So you cannot say, okay, it's my money, it is going out, or it is my money, it is coming in, so you should not be concerned about that. No, the bank has the right, the bank has the right to know about it, and the bank has to act in that particular manner because it is instructed by the RBI to do so. So that also has to be kept in mind.
Thank you, Rina. And in the meantime, we have one question in the chat. This is coming from Yana, I understand. And Yana is wondering if there are any limitations on the stock shares for foreign shareholders of the company. And she clarifies that that may concern certain types of companies or certain types of activities, perhaps, where the percentage of the stock for foreign shareholders might be limited. Do you know of any such cases, any specific situations when there are such limitations?
If I understand the question correctly, is the questioner asking about the employee stock options which are
No, no,
given?
no. Basically, if say there is a company in India and a certain percentage of the company shares is owned by a foreign entity, say a Russian entity, would there be a limitation on the percentage of the stock of the shares that can be owned, perhaps in some specific regulated areas or for certain legal entities, as far as you know?
Yes. So again, a very good question. So there are two types of sectors in India. One is where the foreign direct investment is allowed 100%. So on those sectors, the company can have 100% of investment as through foreigners. So there is no problem in that. So this is called the foreign direct investment, and in most of the sectors it is allowed up to 100%. So a foreign entity can have 100% shareholding, except some sectors where there prior government approval is required. So suppose if you are dealing with the petroleum sector, unless it is for a private sector oil refining or natural gas, or investing in infrastructure or defense industries, or uh, postal services industries, or tea sector. So in those sectors, the you need to have prior government approval. But other than that, in most of the sectors, the FDI is allowed to be 100%. So you can have 100, there is no restrictions on the shareholding which a foreign shareholder can have in those companies.
Mm-hmm. Understood. Thank you for clarifying, Rina. And Yana, if you have any particular sector or activity in mind, let us know, and I'm sure Rina could look into this for you. So another question we received in advance from our audience concerns um, uh, the employer-employee relationships and their regulation in India. Are there any particular features which puts the Indian jurisdiction apart from others? Are there some features of the labor regulation that we should be aware of, that the foreign company coming in and doing business in India should be aware of?
This is a very broad area. So again, it depends on the business, the type of entity, the type of business that the foreign company is looking to set up. If it's setting up a manufacturing unit, if it's setting up an industrial plant, if it's setting up a factory, or if it's just doing import export. So in India, there are lots and lots of regulations about, you can say about 50 legislations which cover different areas of employer employee relationship, the labor, There's a minimum wage act if you employ a certain kind of labor, or if you have a factory, then there's a labor welfare fund act, there's a payment of wages act, and there's an employee state insurance corporation, and there's a payment of bonus act, the maternity benefit act. So there are lots of legislations governed which are governing the employees and the labor which is working for you. So it really depends. So most of these legislations would apply to companies who employ more than 20 people. So usually if you are not doing that sort of labor intensive work in India, and you are only doing, suppose, export import business through India, then most of the legislations would not apply. Of course, some of them would apply, like the maternity benefit act would apply. You have to give the prescribed number of maternity leave to your female employees. Then the industrial disputes act would apply, where all the disputes between the employer and employee would be governed through a certain legislation. So it's again a very industry specific area, and there are it's a very heavily, again, legislated area.
Yeah.
So whatever work you are doing, once we know what the sector is, then we can have a specific answer to that. Otherwise, there are certain legislations which are universally applicable. So you have to give minimum wage act. You have to, depending on which state you are operating in, so each state would have a minimum wage requirement of its own, so you have to obviously comply with that. Then there's an income tax act, so you have to deduct the income tax on behalf of the employee. So these are the legislations which are universally applicable. And then the sector specific and the number of people that are employed with you, then more number of regulations would be applicable to you.
Mm-hmm. Well, I guess one question that people often have in this connection is how easy it is to have foreign employees for an Indian incorporated company, or an employee who is actually based abroad that some trading companies, for instance, like to have. Is that legal in India, and how easy is it to have such employees?
Sorry, I did not get you. A foreign employee who is based in India, or foreign employee based
Or,
outside?
well, actually both. I mean, some companies that need to set up an office, they may want to bring a foreign employee and then place them in India. How easy is it to do that? Or even more often, a company may choose to have some employees that are based outside of India and are just compensated by the company for their services. Is that allowed, and how easy it is to arrange for that?
So there is no restriction in having a foreign employee or an Indian employee or an employee who's based out of India. There is absolutely no restriction on that. From a practical point of view, I would suggest to at least have certain employees here. But see, because in my experience, I have dealt with companies who have just opened a registered office here for the sake of having a proof of address here, and all their employees are based out of India. But then
Mhm.
they do face difficulties because they do not have someone on ground to liaison for them to, really interact with the Indian clients here. Not everything can always be done through online channels. So that's the practical aspect of it. The government does not really care if the employee is working from India, or if the employee is working from outside India, or if it's an Indian employee of or any other nationality. So the government really has no legislations, or I would say restrictions on that. So you can have as many foreign employees as you want. There is absolutely no restriction that the company needs to have a particular number of Indian employees. There is no prohibition for that. So, but again, it's always better to at least have some person on the ground here to also to
Mhm.
understand the Indian market here, to also uh, reach out to the clients here, and because it's a different jurisdiction. So from your home country, from any country, if you're coming in to understand the ground realities, you have to have someone present here for at least a period of time, if not throughout the year.
Definitely. Understood. I guess another broad question that we should spend some time on is taxation, and that's, I think, what people are most concerned with when they come into a new jurisdiction. Very broadly, what should people expect if they're setting up a company in India? Does that depend on the particular corporate structure they choose? Does it depend on the type of activity? Is there a choice between different types of taxation? What is the rough range of the applicable tax rate? Can you say a few words about that?
Yes, like I said, it's again very broad, but since we talked about a private limited company, so let me just talk about that again very broadly. So, a private limited company is taxed on the income that it earns. So, that's called the corporate tax, which is usually 30%, or if the revenue is lesser than a particular amount, which I think right now is lesser than 400 crores in the previous financial year, then the corporate tax on that would be 25%. For all other domestic companies, it would be 30%. So that's the corporate tax. Then there is something called the goods and services tax, which is levied on each stage of the production of goods, on the purchase of raw materials. So it depends if you are you are covered under the GST. So then it would be if you are purchasing raw materials. So at the time of purchase of raw materials, you'd have to uh, give pay GST. And it's a multi-stage tax because at each stage, right from the purchase of raw materials to the production of the goods, to the storage of the goods in a warehouse, to the then selling of the goods to a wholesaler, then the selling of goods to a retailer, and to finally selling of goods to the consumer. So at each stage of this, particular rate of GST would be applicable. But the interesting part is that the ultimate GST would be borne by only the final consumer of the good. So if suppose you are purchasing raw material from somebody, so you pay the GST at that time. It can vary from 5% to 28%. At on most cases, it is usually 18%. That's the most amount of GST. So at you pay goods, you pay GST. Suppose 18% you pay at the time of purchase of raw material. Then when you manufacture goods and then you sell the manufactured good to suppose a wholesaler, so the wholesaler would pay the GST to you, and you would submit that GST to the government and then take a refund of the GST which you had paid at the time of purchase of raw materials. Likewise, when the wholesaler would again sell the goods to a retailer, so then the retailer would pay the GST to the wholesaler, and at that time the wholesaler would seek a refund of the GST which it paid to the purchaser of goods from the raw material. And when the retailer would finally sell it to the end consumer, it is the consumer which would have to bear the GST of 18%, because then the retailer would also seek a refund of the GST. So this is a multi-stage tax in this manner, but the ultimate tax burden is always on the final consumer of the goods. So suppose, but if you are the final consumer of the goods, of that particular goods in India, then you have to bear the final burden of it. And like I said, the range is usually 5% to 28%, with 18% being on most of the categories of goods. And uh, so then there is a and this GST is also four types of GST. So there is a central GST. So this is again applicable on interstate sale or supply of products of services. So if you are selling products from one state of India to another state, so then you have to pay central GST. Then there is a state GST also, where you are selling or supplying goods within a particular state. So you have to give state GST to the state government there. And then there is a union territory GST. It's like when you are supplying goods within a union territories of India, which is the Andaman Nicobar Islands, Daman, Diu, Lakshadweep, Chandigarh. So then you have to pay GST there. And then there is the integrated GST, which is that GST which is charged on the interstate sale or supply of products and from one state of India to another. So again, this integrated GST is paid to the central government. So these are the different kinds of GST. And other than that, there is a corporate tax now, which I talked about. Now, other than these two, so these are the main taxes which are applicable to you. Apart from that, there are, of course, some surcharges and the health and education cess, which is applicable to everyone. There is a surcharge. So, if the amount of income tax can be increased by a surcharge, if there is a specified increase in your income. So, suppose if you have an income of 1 crore to 10 crore Indian rupees, then the surcharge would be 7%. If your income is about 10 crores, then the surcharge would be 12%. So it's a very complicated area, all the taxes also. But just to give you a brief overview, these are the majority of the taxes that are applicable. And of course, then there is an import duty if you are importing. So that's also another duty that you have to be careful of. There is usually no export duty in India. So at the time of export, you can get a refund of that import. So it's really a maze that needs to be covered. But
Right.
this is the broad overview of the tax structure in India.
Right. Well, it sure sounds a bit complicated, but I'm sure that with your help we could navigate that. So you've mentioned how GST differs across different Indian states. So that's perhaps one aspect that people should keep in mind. Other than that, are there any reasons for a particular company in a particular industry to choose to incorporate in one state rather than another? Are there some differences maybe in regulations people should have in mind, or maybe the ease of different dealing with the authorities or other aspects that people should be mindful of?
Yeah, so again, again depends on the nature of the business, but I would say if you are looking to set up a manufacturing unit, then usually the preference is down south of India, which would be Chennai, because it's
Mm,
a number one, it's a port city. Number two, there are lots of manufacturing facilities and industries already set up in that city. So you'll have ample supply of skilled workforce. So
mm,
that's the reason that usually preference is given. And especially if you are manufacturing in railway sector, so there are lots of companies who are already set up there. So that's one of the most preferred destination. And if you are suppose doing business in import export of precious metals, so you are importing diamonds, we are finishing those diamonds here and selling the final product out of India. So then the Indian government has now set up these special economic zones in various cities. So, suppose in Gujarat, again, they have a couple of SEZs, the special economic zones, where you get certain benefits from the
mm.
import duty and the export duty. But if you are setting up in SEZ, then you cannot sell within India. You can only do import and export. You can import from one country and export to another, the final product. So if you are doing that and not trading within India, then you can look to set up there and get some concessions from that area. Again, and suppose if you are doing in some business in some technical sector or an IT sector, then of course Bangalore, or setting up in Mumbai or even in Delhi, now there are lots of startups in IT industry. So, or if your business is such that a lot of licensing is required to be done with government agencies, then either it's Delhi or Mumbai that you need to look into, because that's where the majority of the government agencies are. So again, it depends on the kind of business that you have, but in most of the cities, you would have almost the same sort of infrastructure. The labor is ample in India, so if you are looking for labor supply, you'll find that. But it is depending on what you want to do here. So these are the major countries that foreigners target.
I see. Well, thank you for that. And now I wanted to take you back to employment law because we have a question in the chat. This comes from Paulina, and Paulina is asking, is there a mandatory retirement age clause in an Indian employment contract? Is it mandatory to include such a clause in an employment contract? And also, the second question is whether a company can specify its own retirement age, or is there a standard age that's applicable to all employees in India? Could you comment on that?
When we are dealing with government sector, there is a specific retirement age for government sector employees or employees who are working in quasi government agencies. Also, there is a particular retirement age. Now, most of the private sector employees also follow that retirement age also, which is 60 years. And so most of the companies do have that. It is not mandatory, of course, but in my practical experience, this is what happens. And but in private sector, you can choose your own retirement age. You can choose not to have a retirement age in your clause. There is, as of now, no restriction on that.
I see. Thank you for clarifying that. And Selena, let us know if you have any follow-up questions on that. So far we've spoken about setting up a company in business, but I know that there are many businesses who choose not to set up an entity in India, but they are trading with Indian company, either selling or buying goods or services or contracting otherwise. And the question that people often ask is the choose of the applicable law. And well, oftentimes Indian companies would want the Indian law to be applicable to the contract. That may be something unfamiliar to foreign parties. But as an Indian lawyer, what would you say to that? Do you see any advantages in having the contract governed by Indian law, say if the transaction is between a Russian and an Indian company? Do you see any advantages and any risks potentially for a foreign party and having the Indian law apply to the contract?
Again, Anton, it would depend on the kind of trading that is happening between a foreign entity and the Indian party. So, if, like you said, the Indian party would obviously be wary of choosing a different law. So, it would depend if who the buyer is. Usually, because the buyer chooses the jurisdiction clause, in my experience. So, if the Indian party is buying from somewhere, they would want to have the Indian law as the favorable jurisdiction. And it would also be helpful, I would say, because if the Russian entity or the any other foreign entity is looking to do business in India, then number a, even if they do not choose Indian law in their contract, there are certain regulations and certain restrictions, or I would say compliances, that they would in any case have to comply with uh, under the Indian law. So number one is that the, and if they are looking to raise capital from the Indian market, or if they are looking to raise finances from the Indian banks, the Indian banks would also be more comfortable if the choice of law is the Indian law as opposed to a foreign law. And another thing is that India is a common law jurisdiction. So as UK, it also give weightage to precedents, the law of precedents. And just to give you a brief legal structure of the brief structure of the court systems in India. So there is, of course, the apex court, which is the Supreme Court of India. Then each state have their own high courts, which is the highest constitutional court in that particular state. And then each state below the high court would be the district courts. So each state is divided into districts. So those districts are managed by district courts, which report then to the high court, and which are bound by the decisions of those particular high courts. And then there is all the high courts are of course bound by the decisions of the Supreme Court. So this is the common law principle that India also follows. And so this sort of also brings a uniformity and in all sort of jurisdictions, because irrespective of which state you choose, you would know that what law would be applicable to you depending on the judicial precedents as set by the highest court in the country. So that's a, I would say, another advantage of choosing Indian law, because you would always be sure of what law to what precedent would apply in your particular situation. And other than that, in any case, most of the parties would want to have the arbitration clause as their preferred dispute resolution clause. And to give effect to an arbitral award, India is now really in favor of arbitral, giving preferences to arbitral awards. And in India, if you come to seek enforcement of an arbitral award or execution of an arbitral award, it is really difficult to have a set aside of that arbitral award, even if you appeal it to the High Court and then to the Supreme Court, because as per the government's policy also, preference is really given to arbitration as a form of dispute resolution. So there is only in certain rare cases that an arbitral award would be set aside, if it is completely going against the public policy of India, or if it is so uh, apparent on the face of the arbitral award that there is a brazen mistake in it. Only in those rare cases the award is set aside. So that is also another benefit, I would say, of choosing Indian law. And of course, if you are doing business, majority of business in India, then all the Indian parties would be more comfortable with having Indian law in their contracts.
Hmm. Understood. And since you've touched upon the dispute resolution already in your answer, there's a follow-up I had on that. So um, obviously, there's a choice between Indian courts versus Indian arbitration. That's one choice people have in mind. So could you maybe comment as to the length of the proceedings in the Indian courts compared to arbitration, and also the cost of proceedings? Because these are the two considerations that people typically have when choosing whether to litigate or to arbitrate. And the second sort of follow-up question from that is, oftentimes foreign parties choose to arbitrate somewhere outside of the company of India, say, in a third jurisdiction. What are the arbitration seats that are often chosen by Indian parties if the arbitration is not in India itself? And how easy it is to also enforce a foreign arbitration judgment compared to an Indian arbitration award?
Yes, to answer the first part of your question, whether to choose go the court way or the choose arbitration in your contract, again it depends on the nature of the contract. And if uh, the parties are heavily now relying on arbitration as a form of dispute resolution, uh, the reality of going doing litigation in India is that it depends. If you are seeking immediate relief, if you are in the form of an interim injunction or an interim remedy, then court would be your first step to go, even if you have an arbitration clause, because the Arbitration Act in India provides for approaching of court by the time you are setting up the arbitral tribunal. So before the arbitral tribunal is set up, you can of course approach the courts for interim reliefs. And it depends on which city you are in, which state you are in. So I can talk about Delhi, I can talk about Bombay, and Chennai. So here are the major jurisdictions, and the high courts or the courts here are, I would say, quite favorable to to the parties' concerns, and especially when it comes to grant of interim relief. So the courts are quite well aware of, the judges are very attuned to the commercial business acumen, I would say. But if it's a suppose a tier 2 city and you approach a court there, then you might face some difficulty in getting the relief that you want. But I the Delhi courts are really very capable in that regard. The Bombay courts are also very amazing in handling of commercial disputes. And other than that, so once you have an interim injunction, then of course if you have arbitration in a clause, you go the arbitration way. But if there is no arbitration clause, then the case would linger on. And when I say linger on, it can linger on for 2 years to 20 years. So there are different stages of appeals that a party can go into. So it's a really time consuming process, and that's where it gets expensive also when you choose litigation in the traditional sense, as opposed to, of course, arbitration. So that's why whenever the clients are looking into dispute resolution, they prefer arbitration has become the quickest form of dispute resolution now. The parties are the looking to settle the dispute within 1 or 2 years. There is, of course, appeal also provided. Two stages of appeal you can do, but those are also decided very, very quickly, especially in the states which I just mentioned: Delhi, Mumbai, and Chennai. So, in that sense, arbitration is also cost effective, depending on the number of arbitrators you have on the tribunal and who the arbitrators are. Depending on their experience, maybe the arbitral fees would run up unless you choose to have arbitration under an institution. So there is a Delhi International Arbitration Center, which again is uh, really top notch, I would say. So that again is very cost efficient if you have an institution based arbitration. So you can choose that. And sorry, what was the other part of your question?
There's also a question about enforcing foreign arbitral awards and the difficulties with that, the particular challenges there might be compared to Indian seated arbitrations.
So not really. So only the usual challenges which an Indian arbitral award will also face. The court would only have to look at the foreign arbitral award in the sense of a domestic decree. In the sense, the court
Hmm.
would, of course, analyze first whether the foreign arbitral award does not go against the public policy of India, or it
Hmm.
is not so apparent on the face of it that it is a mistake that the arbitral award was passed, or there is a fraud involved. So the usual challenges which a domestic arbitral award would face. But other than that, the courts are very proactive in giving enforcement to foreign awards. And in
Hmm.
terms of jurisdictions which Indians usually prefer when it comes to choosing a neutral country for the seat of arbitration, I would say right now it's most people from here are preferring either Dubai or Singapore, or even
Hmm.
Hong Kong for that matter. So these are
Hmm.
the neutral destinations that Indian parties are looking at because of the proximity also to India. And the so yeah, these are the neutral destinations here. And London sometimes, but these are the countries which are getting preferences now.
Right, right. Okay, well, thank you for that. I think we'll be drawing to a close maybe within 5 minutes. So if anyone has any additional questions, that's the time to ask them before we have to let Rena go. So feel free to pop anything in the chat box or raise your hands. But if not, then one question we received in advance from the audience, and again, it's a very, very broad question, so I assume you'll not go into a lot of detail given the limited time we have left. But could you say a few words about, IP regulation in India? What is there to expect? How India differs from other countries in regulating and protecting IP rights?
So yes, again, a very broad category, but India is also part of the World Trade Organization, and there are various legislations which give protection to your IP rights. So there is a you can have your patents registration, you can have your trademarks registered, you can have designs. There's a Designs Act under which you can have your designs registered, and then there is a Copyright Protection Act. So India is also, following TRIPS and really heavily protecting IP rights. And recently, there is a new legislation in India, which is the Commercial Codes Act, which was passed in 2015. So under that, all the IP infringement cases are now treated as commercial cases. So there is a prescribed and timeline for resolving of those disputes. So even if there is no arbitration in those clauses, the legislation, the Commercial Codes Act itself provides for a fixed timeline that the dispute has to be litigated in. And there is also pre-court mediation process that the legislation provides in that. So even before approaching the court, it is uh, heavily advised, unless you are seeking an interim relief. If that is not the case, then it is heavily advised that the parties sit together and do mediation and try and resolve the dispute. This is a court regulated mediation, so it is usually more helpful and more successful, I would say. So you can save up on the potential litigation also quite a lot. So that is also one of the major advantages here. So all the IP related issues are now uh, covered under Commercial Codes Act, and they are, fast tracked in that sense. All the litigation in that area has been fast tracked.
Thank you. Thank you very much for that, Rena. I think on that note, we might close the Q&A for today. I know that's been a good use of our time, and I have learned a lot myself personally about Indian legal system today. I'm sure I want to thank everyone for taking part in today's webinar, those who have watched this live, those who will be watching the recording afterwards. It remains for me to suggest that if you have any follow-up questions, please do feel free to reach out to us, to either myself or Rena. This has been brought to you by Cardinals. As you know, Cardinals is a law firm which is centered in UAE, but we have so-called national desk around the globe, and India is one of our national desk, headed by Rena, and given her expertise in Indian law, she'll be able to advise you on all questions related to India and to help your business with navigating the Indian legal landscape. But of course, if you have questions outside of India, don't hesitate to reach out to us as well. We have a very strong practice in dispute resolution, arbitration in particular, but also in overseeing different transactions and helping you navigate legal aspects of various jurisdictions around the world. So do think of us if you need any help with India or elsewhere. And if you have any follow-up questions after today, please feel free to email us. So on that note, I want to thank Rena once again for taking the time to provide us with this presentation. And also I want to thank all of the participants for taking the time to participate in this. So I look forward to seeing you at some point again soon, and to working together hopefully on matters whether Indian related or not.
Thank you. Thank you so much, Anton, for setting this up. And it was really great talking about the Indian legal structure and the forms of doing businesses in India. And I hope um, everyone has learned something, at least something today. And it was really exciting to be able to speak on this topic. So thank you for setting this up.
Thank you. Thank you, Rena. All right. Have a good evening or a good rest of your day, depending on where you are, everyone. And see you some point soon. Bye.